Hey there, this is Jose Jr. Ronnie A and I am from the beautiful black section of PCBet 01402A. We are now done with the section 2 on the obligations of the partners. Let us now proceed to the section 3 of this chapter, which is entitled The Obligations of the Partners with Regard to Third Person. As an introduction, we all know that partnership has been formed to create a business, and in every business, the intention is to earn a profit. In order to have a profit, the partnership itself needs to transact with other people, which are the third persons that are pertaining to this topic. And of course, as they transact with other people or with those third persons, nagkakaroon sila ng obligation sa mga ito. And that leads to our topic for this section, which is again, obligations of the partners with regard to third person. But for this particular video that you are watching, I'm only going to discuss with you the first 3 consecutive provisions in this section, and those are: first, we have Article 1815, the firm name of a partnership. Second, we have Article 1816, the liability for contractual obligations of the partnership. And lastly, we have Article 1817, which is the stipulation against liability. But for now, let us discuss first the firm name of a partnership, which is under Article 1815. It says that every partnership shall operate under a firm name, which may or may not include the name of one or more of the partners. Also, it says that in the second paragraph, those who, not being members of the partnership, include their names in the firm name shall be subject to the liability of a partner. To further understand this provision, let us define first the word firm. Firm is defined as the name, title, or style under which a company transacts business. It can also be defined as the partnership of 2 or more persons or a commercial house. Basically, ito yung pangalan or identity ng isang entity. In this case, yung firm name ng isang entity is tinatawag natin na juridical person because it has a distinct and separate juridical personality from the partners. The question is, why does a partnership need a firm name? To answer that, it is indeed important in order to distinguish the partnership which has, again, tulad nga ng sinabi ko kanina, it has distinct and separate juridical personality from the individuals composing the partnership and from other partnerships and entities. Because according to the general rule, partners may use any firm name that they desired, and this will be the name of that juridical person. However, partnership cannot use an identical or deceptively confusingly similar to that of any existing partnership. That means, aside from the uniqueness ng firm name, it must be registered to the Bureau of Commerce, which is now the DTI or Department of Trade and Industry, so that the firm name will be protected by the law, and that gives you all the right to own that particular firm name. In line with this, partners have all the freedom and rights to choose whatever firm name they wanted or they desire. It can be first, name of an individual partner. Let's say Ronnie Partnership. Second, surnames of all the partners. Let's say Aquino, Datuin, and Jose Partnership. Next, we have surname of one or more of the members plus lalagyan sa dulo ng end company. Let's say again, Aquino, Datuin, Jose Partnership, and company. Next, individual names wholly distinct from the names of any of the members. So, basically, sinasabi lang dito na dapat unique yung name. Lastly, it can be purely fanciful or fictitious. So, pwede kayong magbigay ng name or ng firm name na unrealistic, yung hindi makatotohanan para wala talagang kaparehas. However, there are certain restrictions or stipulation in choosing a firm name. First, we have misleading name. Just like what I said a while ago, as a general rule nga, partners may use any firm name that they desired, and this will be the name of that juridical person. However, they cannot use identical or deceptively confusingly similar to that of any existing partnership, or di kaya mag-interfere sila sa rights ng iba or contrary sa law. bawal yon. Simply put, kailangan unique nga yung firm name ng isang partnership and walang kaparehas from any other existing partnership. Let's take it for an instance, the McDonald's. We are all aware to this McDonald's and one day, nagtayo kayo ng partnership and you wishes to name your partnership a McDonald's also with capital A in Mac. It spells as MAC then Donald's. That's a big no-no because you are deceiving others and you interfere with the rights of the real McDonald's. You are also creating confusion to the public. Next stipulation is use of names of deceased persons. That is persons, not partners. That is very contrary to the law. Let's say the partners wish to continue the partnership and kunyari, yung ipapangalan nila dito is included yung name ng kilalang artista na namatay na para makilala ng mga tao yung partnership nila. That's a big no-no also because it is clearly stated that you cannot use names of deceased persons, sikat man yan or not. Let us now proceed with the liability for inclusion of name in firm name. Ito yung sinasabi sa second paragraph ng Article 1815 na those who, not being members of the partnership, include their names in the firm name shall be subject to the liability of a partner. Of course, di ka naman partner tas andun yung name mo sa partnership na yon. Ano ka, assuming ka girl? You definitely are deceiving others and making look like that you are a partner of that particular partnership even though in reality you are not. And ito yung mangyayari sa'yo dahil dyan. First, you cannot acquire the rights of a partner. Yes, wala ka namang ambag or hindi ka namang kasali sa partnership na yun and you are not partner in the first place, tapos makikihati ka pa ba sa rights nila? Siyempre, hindi na, no? Next, mas lalong kawawa yung deceitful person na yan because he or she will be subjected to a liability of a partner insofar as to third persons without notice or concerns. And that means he or she will be held liable sa third persons. And kapag sinabi nating without notice or concerns, that means hindi alam ng third persons na yon na yung isang partner is hindi siya totoong partner, and that is a good faith. However, when the third person enter into a contract to that partnership, knowing na si isang partner is not a real partner, there will be a bad faith in that. Let us now proceed to the liability for contractual obligations of the partnership. This is the provision stated in Article 1816. Let me read what it says. All partners, including industrial ones, shall be liable pro rata with all their property and after all the partnership assets have been exhausted for the contracts which may be entered into the name and for the account of the partnership under its signature and by a person authorized to act for the partnership. However, any partner may enter into a separate obligation to perform a partnership contract. From this provision, we can categorize it into two such as partnership liability and individual liability. So, kailan siya magiging liability ni partnership? As a general rule, it is written in the first sentence of this provision, partner has the right to make all partners liable for contracts he makes for the partnership in the name and for the account of the partnership. Basically, sinasabi dito na si partnership will be held liable and obliged to that contract and also si partnership rin naman yung magbe-benefit dito. Moreover, si partner can also enter the partnership into a contractual obligation and in that case, that will become the liability of the partnership itself. However, sinabi sa second sentence ng provision na ito that a partner or any partner may enter into a separate obligation to perform a partnership contract. In that case, dito na papasok ang liability of that individual partner, in which a partner may assume a separate undertaking in his name to perform a partnership contract with a third person. Let's say the contract of the partnership is a service. Let's say maglilinis ng condo ni third person. And si partner A, nag-volunteer siya na he will perform the partnership contract himself. In that case, nag-assume siya ng separate undertaking under his name, pero ang nag-benefit ay si partnership. Again, For the separate obligation of a partner, if a partner in his own name enter into a contract with a third person, then it is only the partner or it is only that partner who is liable and not the partnership. Now, let us discuss the nature of individual liability of partners. It can be pro rata, subsidiary or secondary, and lastly, it can be liability of industrial partner. When we say pro rata, it means equally or jointly and not proportionately. When pro rata is stated in the contract, that means the partner will share with the liability equally or dapat fair. Ganon. Let's say ako, si Alisa and si Biel ay partners and may liability kami na 90,000 kay Aika. We agreed to divide the liability pro rata. That means tig 30,000 kami, right? And suddenly, itong si Biel, tumaka siya sa obligation niya. Since pro rata yung contract namin, deadma kami ni Alisa dyan. Di namin iso-shoulder yung liability ni Biel kasi utang niya yun. Kawawa naman kami kung iso-shoulder pa namin yun. So, ganon kapag stated yung pro rata sa contract. Next, si subsidiary or secondary. It means the partners or that the partners are held liable when all assets of the partnership has been exhausted. Dito na papasok yung concept of unlimited liability of partnership. That means hahabulin lang ang mga partners and magiging liable sila sa utang ng partnership kapag wala nang natira or exhausted na yung assets ng partnership. However, kapag may isang partner na naging solidarily liable or yung parang inako niya yung lahat ng liability ng partnership or siya na yung entitled na magbayad for that, that means siya lang yung hahabulin and not the other partners. The last one is the liability of industrial partner. As stated sa provision na ito, kahit ang industrial partners ay magiging liable sa liability ng partnership. Take note that si industrial partner is only liable sa liability ng partnership and not the losses. So that means exempted siya sa losses. Since service yung contribution ni industrial partner sa partnership, wala na siyang babawiin or ikalulugi pa. Hindi naman niya pwedeng bawiin yung time and effort na in-exert niya sa operation ng partnership. However, take note again na yung payment ni industrial partner for the liability of the partnership, pwede siyang ma-reimburse ng mga capitalist partners unless otherwise stipulated. So, to further understand these three natures of individual liability of partners, let's take it for an instance. Oh my God. Let's say, ABCDE partnership was formed by Alisa, Biel, Christine, Diane, and Erica. Then, Alisa, Biel, Christine, and Diane are the capitalist partners and they contributed 50,000 each in the partnership. However, si Erica is an industrial partner. Then, ABCDE partnership entered into a contract obligation to Reynald, the creditor, with a liability of 500,000. The question is, what will be the remedy of Reynald? So, paano siya mababayaran? From the contribution of the capitalist partners, Reynald can collect from each of them. Let's say that pro rata is stated in the contract. Bale, 50,000 times yung 4 na capitalist partners, that would be 200,000. Kaso, 500,000 nga yung utang nila or yung liability nila kay Reynald, that means may balance pa sila na 300,000. Dito na papasok yung subsidiary or yung secondary wherein exhausted na yung assets ng partnership, kaya pwede na silang habulin ni Reynald. So, yung capitalist plus si industrial partner which is also liable for the liability of the partnership, paghahatian nila yung 300,000 na balance nila kay Reynald. So that would be 300,000 divided by 5, 60,000. So from this moment, yung contractual liability nila kay Reynald has been eliminated. So, dito naman papasok yung reimbursement ng bayad ni industrial partner. Since exempted and not liable si Erica sa losses ng partnership, she can demand the reimbursement from the capitalist partners. So, itong sina Alisa, Biel, Christine and Dayan, paghahati-hatian nila yung 60,000 na binayad ni Erica, which is yung industrial partner. That would be 60,000 divided by 4, 15,000 each of the capitalist partners. And that's how the payment or the distribution of payment happen. So take note lang, liability and losses are different in the partnership. When we say liability of the partnership, it comes as the third persons. And when we say losses, it comes between the partners themselves. The last topic that I will discuss today is the stipulation against liability, which is according to Article 1817, any stipulation against the liability laid down in the preceding article shall be void, except as among the partners. So for this one, I will just provide an illustration to further understand this provision. Let's take again the illustration a while ago. Let's say that ABCDE partnership was formed by, again, Alisa, Biel, Christine, Dayan, and Erica. The four capitalist partners are Alisa, Biel, Christine, and Dayan, and each of them contributed 50,000 in the partnership. And of course, Erica yung industrial partner. The ABCDE partnership entered into a contractual obligation to Reynald with a liability of 500,000. But in this one, they agreed and stipulated that Alisa will not be liable beyond his contribution. What does that mean? That means that kung 50,000 lang yung contribution ni Alisa, hanggang dun na lang yon, di na siya pwedeng mag-abono pa. So, ang tanong dito, ano ulit yung magiging remedy ni Reynald or paano siya mababayaran ng ABCDE partnership? Again, Reynald can collect 50,000 pesos from each of the capitalist partners and that would be 200,000 under prorata. So, meron pa silang 300,000 na balance kay Reynald. Dito na papasok yung subsidiary or secondary dahil na-exhaust na nga yung assets ng partnership. According sa provision ng Article 1817, void yung stipulation nila kay Alisa as the third person, which is sinasabi nila na si Alisa daw is not liable beyond his contribution. Pero itong stipulation na to is void nga to kay Reynald. Kasi nga, third person si Reynald and that means may habol pa rin si Reynald kay Alisa. So magbabayad pa rin si Alisa kay Reynald. That would be ABCDE plus si Erica or yung industrial partner na also liable for the liability of the partnership. Paghahati-hatian nila yung 300,000 na balance, that would be 60,000. So from this moment, na bayaran na nila yung contractual liability nila kay Reynald. However, it is stated in the article that stipulation is valid among the partners. That means, after mag-abono ni Alisa ng 60,000, pwede siyang mag-demand ng reimbursement from the capitalist partners or kay na Biel, Christine, and Dayan. Sila yung tatlong capitalist partners na natitira pa. So, si Alisa, magde-demand siya ng reimbursement. So, 60,000 divide 3, tig 20,000 ang babayaran ni na Biel, Christine, and Dayan kay Alisa. Same with Erica, which is an industrial partner and also not liable para sa mga losses ng partnership. Pwede siyang mag-demand ng reimbursement mula kay BCD. So, ganun din, 60,000 divide 3, each of them, Biel, Christine, and Dayan, magbabayad sila ng 20,000 kay Erica. Technically, if you will analyze the distribution of payment, Biel, Christine, and Dayan are the ones who are fully and ultimately liable sa contractual liability nila kay Reynald. Aside from their personal contributions na 50,000 na ipinambayad nila kay Reynald, abonado pa sila ng 60,000 plus inabsorb pa nila yung yung 20,000 ni Alisa and also yung 20,000 din ni Erica. Bale, kung kukumpitin natin, si Dayan, si Christine and si Biel is meron silang 150,000 na binayad kay Reynald, si Alisa 50,000 lang, and si Erica or yung industrial partner natin is 0. And that concludes my report for today. Thank you and I hope you learned something from me. Have a nice day. God bless us all.